Welcome to the Science of Decision Making. We're so glad to have you here today. My name is Megan Hassan, and I'm the field manager for Marion County. We have 8 boards there, and I estimate that over a month's period of time, our boards make an average of 450 decisions per month. Some of those decisions, as you know, are relatively easy and straightforward, but many of them take pause and deliberation and sometimes even debate when you're looking at parental progress. And many times your findings and recommendations are well received by DHS and the parties, but occasionally you'll get resistance from DHS or a parent or a lawyer who doesn't feel like it was fair for some reason. When Judge Geyer and I originally developed this training, we looked at aspects of the decision-making process with a focus on tools that would help CRB members improve their decision-making. And in addition to that, we looked at certain methods that would improve the public perception of fairness and credibility of the board, hoping that as we improve our decision-making practices, that we also improve compliance with your findings and recommendations. Today, Judge Geyer will be talking about that, as well as dynamics of group decision-making. We're very happy to have Judge Geyer here today. He was appointed to the bench in 2011 and serves in Marion County. He also serves as a member of the Judicial Conduct Committee, the Judicial Education Committee, and is on our local Public Safety Coordinating Council. Prior to his appointment to the bench, he served as a prosecutor for 18 years in Marion County, and he was the trial team leader for crimes against children. He also specialized in arson, homicide, and explosives. Please welcome Judge Geyer.
Thank you, and it is really my pleasure to be in front of so many people on a wonderful, beautiful Saturday morning. Thank you for your time today. I only hope that I can live up to what you are giving us to be here. Just before I get started, just to get a feel for who's here, can I see a show of hands? How many folks are CRB board member volunteers? Raise your hand. All right, most of the group. How many people are employees of the judicial branch? Okay, a few. And any other categories? What am I missing? Yes, sir. What brings you here? Your oh, very good, very good. Again, without you, we'd be -1. Geographically speaking, quick show of hands. How many are from Multnomah, Clackamas, Washington County area? Raise your hand. All right. How many from the Willamette Valley? So, okay, good. How many from Southern Oregon? Yes, our chauffeur, long-range chauffeur. Thank you. How many east of the Cascades? Great, great. And how many from Coast Range or west? And anybody that I missed? Excellent, excellent. Well, again, just this great representation of folks volunteering your time. Again, I feel like it puts a little bit of pressure on me to make sure that I give you something. And one of the first things I ask when I'm sitting in your seat, and I go to a training, is what does this person, what puts them in a position to tell me anything about the topic? And so thank you, Megan, for that great introduction. But just a little bit, who am I to teach anything about decision making? Very briefly, as a deputy district attorney for many, many years, I had to make difficult charging decisions on cases. So say if there was someone who shot another person, I would have to make the decision, is this a case where we should charge that person with murder, or was that a lawful use of self-defense? It was also a duty of mine to give my best advice and opinion to the district attorney on whether or not we should seek the death penalty in a given case. I've stood in front of a jury before and asked them to make a decision on a death penalty case, and told them in the frankest terms, because it is such a serious decision, you have to discuss it honestly. It's not a hypothetical. And I told them, I am asking you to make a decision, and I am asking you to return a sentence of death, to sentence this person to die by execution. As a judge, I have to make decisions every day that have huge impacts on people's lives, and I have to help guide juries to make their decisions, to do their job. So I've made a lot of decisions. I know you guys have made a lot of decisions. It's about making good decisions, though. And one of the first things as a newly appointed judge that I got a huge box of books on the subject of decision making, the science and the art of decision making, lots of articles. And the Judicial Department is very interested in making sure its judges make good decisions. They offer regular trainings, and it goes back to things that I studied in college. So that's what I bring to the table, and hopefully this is going to be worth your time. I'm going to go over just a minute what we're going to be covering, the agenda, but I thought just as a jumping off point, we'd look at some quotes from great philosophers. So start with Mahatma Gandhi, who said, "A no uttered from the deepest conviction is better than a yes, merely uttered to please or worse, to avoid trouble." He's talking about bold decisions, the decision being more important than the politics of it. Okay, Tony Robbins, maybe not a great philosopher, but the world's most famous life coach, right? He says, "It's in your moments of decision that your destiny is shaped." We have examples from the Fortune 500 community. It's a picture of Jamie Dimon. He didn't actually say this, but it's a hypothetical conversation between a reporter and a CEO. And the reporter asks, "Sir, what is the secret of your success?" CEO says, "2 words. "And sir, what are they?" "Good decisions." "And how do you make good decisions?" "1 word." "And sir, what's that?" "Experience." "And how do you get experience?" 2 words. "Sir, what are they?" "Bad decisions." From the sports world, we have tennis great Billie Jean King, who says, "Tennis taught me so many lessons in life. One of the things it taught me is that every ball that comes to me, I have to make a decision. I have to accept responsibility for the consequences every time I hit a ball." So she's talking about personal accountability for your decisions. Also there, though, she's talking about what we call the butterfly effect, the unintended consequences of your decision. From literature, To Kill a Mockingbird, we have Scout, who said, "We can't always have our druthers." A few decades later, paraphrased by Englishman Mick Jagger, who said, "We can't always get you can't always get what you want." From film, now Mr. Miyagi didn't exactly say this in The Karate Kid, but it sounded like something he would say. "If you chase 2 rabbits, both will escape." Again, talking about being decisive. And then my personal favorite, Dirty Harry, "A man's got to know his limitations," or more likely like this, "A man's got to know his limitations." Now, again, let's bring this up to date. A person's got to know their limitations. I promise you all of these are going to tie in to the presentation somewhere. We'll be seeing echoes of all of these later on. So the overview of what we're going to cover today. Going to cover different types of decision makers. So I want to go around the decision-making process and kind of kick the tires all the way around. And we make lots of decisions, but we don't always know what's at work, how we're getting there. And so I want to look at the different types of decision makers. It's important to look at the kind of the decision that's being made, the kind of evidence that you can use, relevant evidence and irrelevant evidence, and the dangers in using irrelevant evidence, concepts of unconscious bias and confirmation bias. Got some scattered topics toward the end. After about 1 hour, we're going to take a 10-minute break. When we come back, I've got a group exercise for you that we'll pass out as you're leaving. And then I want to wrap it up with some on the dynamics of group decision making. And that's what's going to relate most directly, kind of tie everything together to what you do as CRB members. So starting with different types of decision makers. Yes, sir?
So you don't mention anything about if you know what a expect a standard outcome? How that affects your decision?
I'm not tracking your question.
Okay, so
You know what? Maybe this sounds a little more complicated. Maybe we can talk over the break. And if I haven't addressed it, because I'm not tracking where you're coming from, but I want to answer it, and it may be something that we want to bring up for everyone here. But just going through again, kicking the tires from all angles. Want to look at different types of decision makers. I thought that the 2004 presidential election gave us two types. Two ends of the decision-making spectrum. So we have former Senator, current Secretary of State John Kerry, and former President George Bush. Two very different types. One I'd call the deliberative decision maker, and one on the decisive end. They both bring positive traits to the process of decision making. For the deliberative type, they are thoughtful, they're not rash, and they're going to respond to the new information that comes to you continually. For the decisive decision maker, they're firm, they're confident. President Bush used to say he makes decisions by his gut. That's something that researchers actually study, and they call it the intuitive decision-making process. And if you read the book Blink by Malcolm Gladwell, it's surprising how accurate the intuitive decision-making process can be. There are also negative traits for each type, being on ends of the spectrum. For the deliberative, they can appear indecisive. They are likely to be called flip-floppers. They can suffer from paralysis by analysis. In the classic ready, aim, fire mode, their fault would be ready, aim, aim, aim. On the other end, the decisive decision maker could appear to be rash, stubborn, strike some as arrogant, and if they're going to fault to one direction, it's going to be ready, fire. Between the two ends of the spectrum, I would suggest is the sweet spot. So if you're a field manager and you're comprising your boards, a good mix of both types, or in your personal practice, a lot of us have traits of both types of decision making. That's what's going to give you the classic ready, aim, fire mode of decision making. So I've got the next set of slides. A lot of these allude to new information, and that's one thing that's very important to remember, that new information is always going to be coming in, and it may be that last new piece of information that may change the outcome of the case. And so as you're going through the decision-making process, when should you decide? Again, it depends upon the context. If you're a soldier on a battlefield, or if you're a police officer in an armed confrontation out on the street, you're going to have to, your life may depend on making a very quick decision based on incomplete information. If, on the other hand, it is part of a deliberative process, what I'd call due process. Now, there's books and books and books that have been written about due process, but bottom line, due process is where there must be a formal process for a person to have their issue heard. So in criminal cases, there's due process. In most disciplinary proceedings, whether it's a professional disciplinary proceeding or educational, or with the CRB, there is due process that's required. And I would suggest that the fatal flaw, if you are in a situation where due process is required, is deciding the case too soon, before you've heard that last bit of information. This squares with what we instruct juries. So here is Uniform Civil Jury Instruction 5.01, and it says basically what I've just told you. Jurors should not begin to deliberate until the end of the case, after they've heard all of the evidence and the legal rules that apply to that evidence. Again, this is something that we've known for a long time. Hearken to the words of the immortal philosopher Yogi Berra, who coined the phrase, "It ain't over till it's over." Now, Some of you might be sitting there saying, so wait a second, so I sit here and I don't think about it until the end. That's not what I'm saying. It is very fair to know where you stand on the decision at any given moment, all right? And I've got this picture of the two glasses there to give you an example. Keep an open mind, and as you hear the information, you may be constantly pouring the water from one glass to another. At the end, you're going to be looking at which side or which party has the quantum of the evidence in your case. So you're constantly responding to new information, new facts, but again, you know where you stand at any given moment. I have a case example to tell you about. One time when I had a very serious child sexual abuse case, and the other side was seeking to introduce some scientific testimony that to me struck me as junk science. So we had a hearing in front of the judge. We had it set for an hour. The judge was going to hear what the evidence was and hear our legal arguments and make a decision. The other side still wasn't done putting on their testimony of this after an hour. Still not done after 2 hours. Still not done as we're getting on to 3 hours, and I'm saying, Judge, now, I have some questions for this witness, and we're almost out of time this morning. We came back in the afternoon. It was a very persuasive witness. His job as a professional witness, if you will, is to deliver a product. So he is hired a lot in places around the state to testify about things. I was really worried that the judge had made up his mind, but by the end of my questions, the judge understood where I was coming from. He kept an open mind, and after a full day of hearing this, he was persuaded that this was not evidence that was proper for the jury to consider, and they did not. And just so you can rest easy, the Court of Appeals approved that decision. That was appealed. So another thing to consider is, what is the decision to be made? A lot of times we make decisions not on the question before us, but on other things that aren't really what we're considering. I'll give you an example. I have to decide a lot of child custody cases, and in the process of those, there are custody evaluators that may be hired by both of the parties as a neutral to look at both parents, look at the children, look at the situation, and make a recommendation to the court. In seeing the testimony of one of them, she described what she felt her job was. The legal principle that guides my decision at the end of the day is the best interests of the children. That's what the law on that says. And she described her job as, Judge, I'm going to take all of this information, because there's a lot of personal hurt that the parties have in this process that isn't relevant to the best interests of the children. It's relevant to the breakdown of their relationship as a couple. But she said, I'm going to take all of that, and then I'm going to just take the information that shines a light on the best interests of the child. And I thought that was a great description of what the decision really is that is to be made. You also need to know what your burden of proof or burden of persuasion is, because that may differ from the context you're in. In a criminal case, it's going to be the highest standard of proof that the law recognizes, and that is beyond a reasonable doubt. Not beyond all doubt, not beyond a shadow of a doubt, beyond a reasonable doubt. In most professional discipline type cases, it's going to be proof by clear and convincing evidence. There's also proof by a preponderance of the evidence, which is just 51%, or if we're looking at those two water glasses, the one that has just a little bit more water in it than the other. Then there may be lower standards like reasonable suspicion. So those are the types of decision to be made. You need to look at what the burden of persuasion is. Now, what kind of evidence can you use? Anyone remember the old Dragnet show with my man Friday and Webb. So what was it that they said every time they would go out into the field, they'd be investigating, and someone would start to say, now, I've known him, and he just doesn't seem like the kind of person he would do that. They would stop and interrupt and say, what? Just the facts, ma'am. Just the facts, sir. Compare facts to opinion. Anyone, I'm sure we all probably followed the events in Boston a couple weeks ago. Horrible week, right? Does anybody remember when they were talking to kids that went to high school with the younger of the two men who were accused, Jokar, I think his name is. His friends from high school, his friends from college, kids that are just like our children and our neighbors were shocked. And the actions were so different from the guy that they knew that they thought, well, he just couldn't do that. I heard one on the radio saying, no, I don't care what you show me. There is no way I will believe that that is the person that did that. That's an opinion, and everyone's got them, and that's their right. But I hope you can see that as far as the value of the evidence, things that you see, things that someone sees, hears, tangible physical evidence, that is different from an opinion. Now, it's not to say that all opinions go out the window or all arguments. When attorneys and caseworkers come to you, they may be giving you opinions or arguments, the value of which may be you may hear a string of different pieces of evidence, and they may connect the dots for you, show you how these different pieces really are relevant to the decision that you're making. On the other hand, we hear arguments and opinions all the time in jury trials. And again, there are jury instructions. So just to show you that I'm not making this up, this is the law as far as formalized group decision making in courts of law. Here's a couple of examples from civil and criminal jury instructions. Again, opening statements and closing arguments of the lawyers, they're not evidence. They're there to help you understand what the evidence is. Also, as the decision-making body, so the jury or you as the CRB, it is your job to decide the facts. What happened? You may hear contradicting evidence. One witness may say it was fact A. The next witness will say it is fact B. You are to decide what evidence is worthy of belief and then apply those facts as you determine them to the law that applies to your case, the law or the rules. And finally, always instruct the jury that you cannot ignore the law or the rules that apply to your case. I'm going to skip ahead right here. Now, I said that facts matter more than opinions. With every rule of law, there's always an exception. Sometimes there's 16 exceptions. There are certain professionals who part of what they do is they give an opinion. You go to the doctor will tell you certain facts. Well, your test shows blah, blah, blah. But then what you want, so what are you saying, doc? What should I do? And your doc will say, I think you need surgery. Or you, if you're lucky enough to have a stockbroker, your stockbroker will tell you facts, but then interpret those facts and give you advice or opinion. Now, just like in your private lives, in a decision-making process, those people with specialized knowledge can give opinions in courts of law and are relevant for you to receive opinions on. Which brings us to the issue of relevance. If there is one guiding principle of what juries can consider in jury cases, it is the concept of relevant and irrelevant evidence. So I've got a little cartoon up here to kind of highlight it. One mountaintop says to the other, I don't know, the meaning of life just doesn't seem relevant anymore. So as I go through this, I would like you to think of examples of issues that you have in the course of your deliberations while we go through relevancy. So let's start with the rule of evidence. The rule of evidence is whether that piece of evidence tends to prove or disprove the matter sought. If it doesn't, then as my friend's grandma would say, what has that got to do with the price of tea in China? So let me give you some examples. And I'm going to pull these actually from real cases, but I like sports analogies. So go to the game of baseball, right? You are the umpire. You are calling balls and strikes. Does it matter? Does it matter if the batter is a really, really good guy? It's close. You think it's a strike, but you really, really like the guy. Should that make a difference? What if the pitcher is a really good guy? What if he's just had a real hardship? You know that he's just had a tragedy in his life, and he's really pitching, and it's an important part. Does that matter if the pitcher is a good guy? Or what if one of them is a bad guy and you don't like them? It doesn't matter to calling balls and strikes, right? You're looking at facts and you're applying them to the rules of the game. Wouldn't you think it would be wrong? Wouldn't it strike you as wrong if the umpire, knowing that one of those was a really good guy, but their call was going to determine the game, it was 2 outs in the ninth, and that influenced their call? Now I ask you, that's just a game. That's just a baseball game. That's nowhere near as important as any of the work that you're doing. But yet, those determinations, whether you're aware of it or not, they bleed into what we do. There was an attorney in town when I first got started trying criminal cases. He was the guy, if you were a rich doctor and you had a few too many drinks and you got charged with driving under the influence, this was the guy that you would hire. And he got 10 straight not guilties before we kind of figured out what was going on. Every trial, he would start off by telling the jury, my client, he's a really, really good guy, good community guy. He's married, wife is great kids. You're going to hear from him. You're going to hear from his friends. They're good guys, good people, and they're going to tell you he was not intoxicated. Well, we finally started making a motion to the judge saying, Judge, it violates the rules of evidence. He shouldn't be calling his client a good guy. That's personal vouching unless he wants to get up and be subject to cross-examination. And I happen to know that he has so many cases he has to keep a Polaroid of his clients in the file so he can tell them all apart. But in any event, it's just to highlight how this stuff really, we put a lot of value on this, and we put value on it sometimes over the actual facts that we're dealing with. Another example that may be relevant to what you do is the status of the criminal case. I know that comes up sometimes in the context of reviews. Remember, criminal cases are subject to the highest burden of proof allowed by law. And so the fact of a dismissal or the fact that a case is not charged or that someone was found not guilty, that means that in the eyes of the law, they cannot be punished for that. But what you do is not punishment, right? I'll give it to you another way. And I hate to sound hard, but the presumption of innocence, very important thing, but it is a legal fiction. And you would recognize this if someone commits a murder, but they are never caught, charged, or arrested, they are innocent in the eyes of the law. That person isn't any less dead. So again, this is a recognition of the law. So remember, there are differing burdens of proof in the criminal case and in what you do. Now I want to move on. I mentioned unconscious bias and confirmation bias. I also want to talk a little bit about the perception of bias. And I've got this little cartoon there where at a review session it starts with, let's begin the meeting, but be aware that I am documenting all your bullying behavior. Dilbert says, I'm not even close to being a bully, but now your confirmation bias will make everything I say sound like bullying to you. The response is, can you repeat that last part after you called me a delusional witch? So let's go from here right to the video. I'm going to show you a bit. Would someone be so kind as to get the lights over there? Thank you. And the instructions are going to be plain enough. Just follow the instructions, all right?
This is an awareness test. How many passes does the team in white make?
Go!
The answer is 13. But did you see the moonwalking bear?
Go!
So obviously an ad that was designed for something else but has been used in a lot of decision-making studies and training. And what we get to in looking at unconscious bias, we are all hardwired to use bias. It's something that has scientifically been built into us for our survival as a species. So you go back to ancient humanity, and a person is walking around in the forest, and all of a sudden, all of the chirping of the birds and the bugs goes right down. And that person doesn't have the time to process everything of what it means. They know there's a saber-toothed tiger, and they don't know quite how they're making the decisions, but their brain is taking the shortcuts. We have to rely on that all of the time because we are tremendous supercomputer processing machines, but we have our limitations as well. And that can sometimes lead us into this area of unconscious bias. If you want a little bit more detail, I had mentioned the book Blink by Malcolm Gladwell, and he discusses some of these intuitive shortcuts we take and how when it's in an area of your expertise where you are familiar with a lot of subtle nuances that you may not be processing at the conscious level, those intuitive decisions that you make in a blink of an eye can be amazingly accurate. But also, as in here, it's easy to miss what you're not looking for, as I said. Related to unconscious bias, but different, is the phenomena of confirmation bias. And to explain this to you, the best way that I can break it down is that we perceive things and then we interpret them. But our expectations can affect what we perceive. And again, that's exactly what was going on in the dancing bear video. We were expecting one thing, and most of us totally did not see something else that was right there in front of our face. In other words, we can be guilty of cherry-picking the data to conform to what we were expecting to see. And this is something that's confirmation bias. It's often cited in scientific processes. That's why in many scientific processes, they utilize blind tests or placebos to make sure that there's not confirmation bias that is dripping into the interpretation of the results. I mentioned an expert witness and my experience with them. And again, I don't mean to discredit expert witnesses. When you have a legal case, you may be in need of an expert witness. You may need to hire one. It's just important to know the situation from all around. Anyone ever heard of the attorney Mel Belli? He's going back a few years. Great. He was a high-rolling plaintiff's attorney. His nickname was the King of Torts. He was asked about neutral or impartial witnesses, and his famous quote was, "If I got myself an impartial witness, I think I'd be wasting my money." But it is worthwhile in the decision-making process, as Clint Eastwood said, we got to know our own limitations, so we got to explore our own biases, because we all have them. Again, it is natural, and it is what has helped us to survive. So I've got here some stereotypes, some biases that we may have. I'm not saying you do, but they are certainly out there. We know that people carry some of these stereotypes around with them of the caseworker, of the attorneys, and of the parents. And they may be true in the vast majority of your experiences, but that doesn't mean that they're true for the next case that you see. Every case is unique. I mentioned the perception of bias, and this is important. One thing that I have always tried to remember as a judge is that while people come into my court believing in their case, and thinking that they're going to be successful, and they want to be successful, at the end of the day, most of them do know that there's a possibility that they might not get the result that they were looking for. So they want to win, but they better be heard, okay? They can come out feeling just fine about the process if they've heard, but they felt like they had their day in court, right? We all know that phrase, I want my day in court. People have a story and they want to be heard. And for them, their perception of not having a fair process, that's their reality. And that's going to be the reality for all of the people that they talk about their experience with. So their experience, their perception of the process that we provide them, that goes to our credibility as an institution. And I think it's important in maintaining that credibility. So in maintaining an appearance of neutrality, think about what your face is showing. I often mention to people when we're just about to receive a verdict, half of the room may be devastated, half of the room may be overjoyed. And one half better not be acting out, one half better not be hooping it up and high-fiving. I tell them, I want your best poker face. Well, that's something that I have to maintain as I sit on the bench as well, and I would submit to you that you should consider. Be conscious of how you make sure that you're treating those that come in front of you, all of them, the same. Be careful, be conscious of your body language, and for people to have their day in court. I know that sometimes we have to move things along and we do have to cut people off, but make sure that you give them an attempt to be heard with that. And as far as overreacting to certain pieces of evidence, just imagine if you came to see your friend's case in front of me, and while he was telling his story, I was going like that and making faces at it. Would you feel like your friend got a fair shake in court? Probably not. So again, it comes back to what your face says, what your body says, what your treatment says, and your speech, your tone, your language. How am I doing on time, Megan?
20 minutes.
Great, okay. Some miscellaneous things on decision making. I've got a picture up here from the movie Anatomy of a Murder. Anyone who's seen Anatomy of a Murder? All right. This is from a scene that is discussed in a lot of legal ethics class, and I've got it here to help you understand or to highlight some things about the role of an attorney. All right. So the basic premise behind Anatomy of a Murder is you've got a very young Ben Gazzara right there. If I remember right, Ben Gazzara has been charged with the murder of his wife's lover. He shot the man in a bar, and he's trying to hire small-town attorney Jimmy Stewart to represent him. And so in their first meeting, Ben Gazzara is talking about what Jimmy Stewart's going to do for him as his lawyer, and Jimmy Stewart corrects him and said, "Oh, no. I haven't decided to take your case yet. I got a few questions for you before I do." And he said, "Well, what are you talking about? You know, I've got the money to pay you." He said, "Yeah, but I got a reputation here, and you know, paper says you just walked into a bar full of people and shot that man in cold blood. Got witnesses all over. Yeah, I'm not going to take just a loser of the case. I got to talk to you, find out if you got a defense. So don't say anything, son, but just listen to me for a second. So if you heard that this man was carrying on with your wife and you just up and shot him in cold blood, well, you're guilty of murder, and I got nothing to defend you on, and I'd rather be fishing, all right? But if you found out about it and you felt an irresistible impulse and everything went black, you might have a defense. Now you can talk to me. So tell me, how was it?" He says, "When I heard about it, I felt an irresistible impulse and everything went black. The next thing I knew, I woke up and there was a smoking gun in my hands." And Jimmy Stewart says, "You catch on fast, kid. You got yourself a lawyer." This is, of course, you know, a lot of lawyers take umbrage to the scene. It's not to say that this is how it goes, but a lawyer is an advocate. Just remember that. A lawyer is an advocate. They can be very, very helpful to the process. And, of course, if you ever need one, I want you to get the best one that you can and the most helpful one. But they are an advocate. So while they may be helpful to the process, they are always supposed to be zealously representing the interests of their client. So, for example, you might have an attorney who represents an 11-year-old. That is to be distinguished from a situation where you have an attorney who is a guardian ad litem for the 11-year-old. The guardian ad litem is going to use their judgment and experience to make decisions in the interest of the 11-year-old. But the attorney who's representing the 11-year-old, who's driving that ship in the end? They are representing the interests of the 11-year-old. So it's kind of like the boy king situation. Remember, the attorney is an advocate. That's why you never hear them say this. So, questions on anything so far? I don't know, did I get even close to what you were bringing up?
One decision, let's suppose I need to go to Seattle. I have to make a decision as to whether to go north or south on my flight. That's a kind of decision. But these kinds of issues don't come up in that kind of decision because it's obvious. So I need to go north if I want to get to Seattle. And I think similarly in CRB meetings, those are the kinds of decisions that we have to make in many cases because, for instance, with respect to immunizations, you can say, well, they got some shots, so they're immunized. But that isn't really correct. I mean, if I didn't know I wanted to go to Seattle, I would never get there, or it would be unlikely because I wouldn't know which way to go. Similarly, you need to have a standard. Right? There's a standard for immunizations. You have to look at the standard and say, what do you got compared to the standard? And then make a decision as to whether it matters.
Right. You look at the question in front of you, the facts that are on that, and then the legal rules that apply to making that decision.
So you call your experts as opinions, but really, in the CRB, the expert expected outcome defined by an expert, such as what immunizations a child should have at a particular age, that's an expert opinion, the way you call it. But from the CRB point of view, it's a standard to which we compare.
Well, you're a little bit more into your specialized field where I don't know the particular rules, and I think that I'd be outside of my expertise if I tried to address that. The important thing to know is from your field managers, your facilitators, or if you are a facilitator, you're going to have the rules that you need to apply. And I don't know that there is anything that would say that any kind of testimony is necessarily binding per se. So if you had testimony that was in front of you, but you found it utterly unconvincing, utterly unworthy of belief, do you have to take that in that context? So what I'm going to try to do moving from here into the next, I've actually got some examples now in this very next slide that address some common issues in CRB to maybe highlight what's going on here. And then in the second half, we're going to take a break coming up here, but in the second half, I'll talk some about group decision making, because there are a lot of dynamics that aware of it or not, can really pull us to a hasty decision or suck out a lot of the value of the group and have it be the decision of the most influential or powerful personality in the group. But going to this, here is a hypothetical for you. Mother is arrested based on a founded incident of child abuse. The child is placed in care, and jurisdiction is based on physical abuse. At first review, you find out the mother is pregnant and engaging in a parenting program through Family Building Blocks, which is that's a local service provider in Marion County. Mother has also recently participated in a psychological evaluation. So evaluate the appropriateness of the following questions in relation to reasonable efforts and parental progress. So the first question in the review is directed at the mother. What are you learning at Family Building Blocks? Relevant question? Who says it's relevant? Raise your hand. Okay. Someone wanna say why? Yes.
Well, she's learning parenting skills and learning from Family Building Blocks how to be a good parent, how not to abuse or neglect, changing the dynamics of her family and change what and how she was raised.
One of the decisions to be made is parental progress, and that question is designed to measure that in some way, right? Great, thank you. Next question: is the DA's office prosecuting the case? What do you think? Now, I'm seeing a lot of heads shaking no. Kind of goes back to an earlier slide that, again, it may or may not mean something. It may or may not. But again, you're to make your own decision based upon the evidence that you have at your disposal. Next question, number 3. What services are being offered to mother to prevent or care for her unborn children? I heard a no right off. Where was that? Oh, yes, and explain.
Well, the unborn child is not under the care of the court.
The unborn child is not under the care of the court. So again, it's not in the scope of the decision that's before you. Question number 4, does mother have a job? I don't want to make this a trick question, so I'll utter it in the way I think it probably comes out. Does mother even have a job? When you hear it like that, what do you think? I hear no's. Someone not applicable. Doesn't answer. Now, I will say a qualified no, because if we're getting into measuring mother's progress and she's talking about things she's been able to do but things she hasn't because she's got this new job finally and been able to keep an apartment and she's trying to balance the job with it, then it may be. But the way I asked the question, when it comes out like that, it wasn't even a question so much as venting, which again I completely understand. But just measuring the question. What about question 5? Do we have a copy of the psychological evaluations, and what were the recommendations? Relevant question? Yes, I'm seeing a lot of raised hands. Yes, sir. Yes. Most likely it is there because there is some nexus to the physical abuse, and that's what's really going to be key, is the relationship of that evaluation to understand the services that are necessary or the services being provided. And last, number 6, Mr. Smith, the lead caseworker, failed to document face-to-face contacts again. Mother, question to the mother, did the caseworker attempt to have in-person contact with you in the last at least every 30 days? It's a, I'm hearing disagreement. The part about contact within the last 30 days, absolutely. That is a requirement. It is absolutely relevant. This is, I will say, I'm sorry, it is a trick question, though, and there is one word there that is key. And can I hear from someone who says no? Again, the word again, and why do you focus in on that?
Because it brings in issue not in evidence and not relevant to the specific question. It's derogatory toward the caseworker.
It's not necessarily clear from the way that I phrased the question whether we're talking about in this case or in another case, but a lot of times what we see, we see the same people again and again, and sometimes we see them make the same mistakes again and again. But as I said earlier, every case is unique, and just want to be careful about the perception of bias, because if we are talking in this question about other cases, then it tends to suggest that we formed an opinion before we've even heard the answer to the question. So both observations, very good and right on the money. All right, at this point, let's take our 10-minute break. Just talking about decision making, I couldn't decide between the two photos of the workers at break or the puppy. But so we are at, I've got 11:23, so a little bit past 11:30. We'll get back together for part 2. Thank you. Yes.
When you're ready to go.
Okay.
Do you need a little break? You okay?
No, I'm good.
And I'm going to, you would like me to give the microphone when people speak?
Yes.
So I will be up and around doing it. And they'll have their scenario on the table.
Okay, great. Thank you. All right. Anyone mind if we get started here? So, you know I like quotes, so I have another one on decision making. Abraham Lincoln said, "Don't believe everything you read on the internet just because there's a picture with a quote next to it." Or, I don't know. I think he did. Maybe not. All right. So for the remainder of the presentation, what I want to do is to have you guys go to work on a group decision-making exercise. So I think what I'll have you do, there are written copies that are available. If you don't have a copy, raise your hand, and Megan will get you one. However is best for you to review it. Let's do that now. For some that are oral or want to read it on the big board, I'll have it there. But what I'm going to ask you in the end, what I'm going to ask you with this is there is a situation that happens, and I want you each at your tables to discuss who took the chocolate mousse. Come to a decision on who you believe took the chocolate mousse. It's a whodunit. The next question I want you to answer is, what will you do? What will you do about it as the parent of the culprit? And then finally, what I want most is to hear how you made that decision. So we'll review it. I want you to talk about it as a group. And I do want you to elect a spokesperson to briefly walk us through those questions. Take about a minute to answer those questions for us. I don't think in discussing this with you that I'll be able to get to every table. So at the when we get back to talking as a room, I'll be looking for volunteer groups. Okay, so you can go ahead and read it to yourself. But for those who want to read along with me. And by the way, this was an exercise designed by former Supreme Court Justice Mick Gillette and former Circuit Court Judge Pamela Abernathy. The purpose of this exercise is to examine and expose the way in which you solve cases, i.e. the way in which you judge. But the following scenario has no plaintiffs, defendants, no rules of evidence. Instead, it has two young people and a missing bowl of chocolate mousse dessert. You are to read the problem, spend a few minutes by yourself solving it on your own, meet with your small group to seek a group solution to the problem. After you've had an opportunity to thrash out its solution, each group will present its resolution of the problem to the group as a whole. You are the parent of two children, a boy, age 12, and a girl, age 9. The following is a brief biographical sketch of each. Tom is age 12, small, lithe, physically very quick, bright, but with a tendency to slough off his studies. So much so that you found it necessary to cut off his playing Nintendo games until he has read 3 books. Although he presently is very put out, and your handout may say Xbox. I tried to update this. Hopefully it did. Although he is presently very put out with you for taking away his video games, Tom has always been a sunny, outgoing child, confident and honest with adults and his peers, rarely needing discipline of any kind. However, he has been showing the first signs of the onset of adolescence: secretiveness, a passion for privacy, a tendency to be sullen and resentful. Keeps a neat and tidy room. He loves chocolate. Jane, age 9, is a tomboy, very athletic and independent, bright like her brother, but solidly interested in books rather than video games. She is mischievous, at times flagrantly disobedient. She is presently grounded for going to a friend's house after school and not letting you know where she was until after 6 p.m. She seems to resent being treated as younger than Tom, but never blames him for that. Lately, Jane has seemed to be growing out of her mischievous phase, and the recent visit to a friend notwithstanding, has seemed far more ready than in the past to obey the rules of the house. She keeps the messiest bedroom that you have ever seen. She has a tendency to overeat sweets, also loves chocolate. You are having guests to dinner. The dessert is to be specially prepared chocolate mousse done from scratch. 4 bowls of the dessert have been left in the refrigerator with specific notice to both children that they are not to touch the bowls. After dinner, you go to the refrigerator and you discover that one of the bowls is missing. You serve the desserts to your spouse and the guests, leaving yourself out. The children have had supper by themselves in the kitchen. Tom doesn't seem very hungry. Part of his supper remains untouched. Jane eats everything put in front of her. After dinner, you confront both children. Each denies taking the mousse. Each declines to speculate as to how it has disappeared. Tom has never, to your knowledge, lied to you about anything of any importance. On the other hand, he seems generally truculent, still smarting from the loss of his Xbox. Jane, who is unhappy with being grounded, has lied to you many times, but usually you can tell when she's doing it. This time, you cannot be sure. Both children had access to the refrigerator during the afternoon, Jane for an hour longer because she came home from school an hour earlier than Tom did. A check of both children's rooms discloses a paper towel with smears on it that might be chocolate in Tom's room. So far as you can tell, there is nothing in Jane's room that is pertinent. The missing dessert bowl, empty but for a very clean spoon, is found in a cabinet in the bathroom that is located between the 2 children's rooms. You consider the theft of the mousse to be too serious to ignore. You feel that you must name the culprit and punish him or her. So how do you go about deciding which of your children took the mousse? What assumptions do you make as you start the process of solving the theft? What biases do you have toward each child? What factors seem to you the most important in deciding who took the mousse? Why? What factors seem least important, and why? Once you decide, what punishment will you impose? Or as I said, what will you do? In your house, by the way, physical punishment is not practiced, so you have some limits here. Remember, you can't ignore the law, can't ignore the rules of the exercise. Grounding is never for more than 2 weeks. All right. So go ahead and have at it, and I will be by and by to facilitate. How are we doing? Can I just see a quick show of hands for the number of tables that are ready? Just a quick show of hands. I know that there are a few. So 1, 2, 3. Okay, and how many need more time? No one needs more time? Okay, that is an answer too. All right. Okay, do we have a table that would like to volunteer to go first in letting us know who they, as a group, think took the moose, what they will do, and tell us a little bit about how, as a group, you came to your decision? Volunteer, or am I going to have to? Oh, okay, great. I've got a couple. We'll go right here first, right in front of me. Oh, right in front. Okay, are you the spokesperson? Okay, I have a microphone for you so we can pick you up on the video so that folks who watch can hear.
All right, we both feel, by just one line only, that Jane is guilty. And my reasoning is because keeps a neat and tidy room. The kid who keeps always a neat and tidy room is not going to leave a dirty napkin the floor. The girl did it. She planted the napkin. Woo!
But that's two of you, right?
Yes.
And I'm sorry, can I get your name and where you're? No. Just where do you serve?
Ellen Logger, Columbia County.
Nice
Larry
to meet
Payne
you.
in Marion County.
Oh, thank you, sir. Good to meet you. I just wanted our spokesperson. So that was one half. Tell us about, but it's a split decision.
The other half feel that it's all circumstantial, and that what they felt is that to ground both of them, just plain ground both of them, and then finally that they will settle it and say, come on, you got to fess up because you know I didn't do it. And so that when the one who fesses up and says, all right, I did it, they continue the grounding. Is that pretty accurate?
All right.
And the other one is off the hook.
So insufficient evidence to make a decision, so we'll punish them both, but give an out for the guilty to step forward and relieve the punishment.
They'll still
of the
get their
innocent.
punishment,
Mm-hmm.
but
Yes.
the one who is innocent would
Right,
not. But
right.
I disagree with this because I'm a believer in spanking. I mean,
Okay,
I
that's
don't-
another debate.
Yeah,
We're
I
not
know.
going
I don't-
outside the rules of the exercise.
I don't mean beating.
This isn't a judgment
Yeah.
thing. It's
Yeah, so that was our.
So tell me, right? Tell me a little bit about. So you were not able to come to a consensus as a group. Tell me a little bit about that process.
We agreed to disagree.
Very good.
I mean,
All right.
I'm not going to change their minds. They're not going to change my mind. I've already made up my mind. Heck, kid's guilty.
All right. Very good. Thank you very much. And I saw a hand, the group behind you. Would you just your first name and where you serve?
Eleanor Beatty. I serve in Clackamas County.
Thank you.
We don't think there's enough information to make a decision to pin it on any particular person, and there's a distinct lack of information about the spouse. So what we would do with this is there would be a conversation with the entire family. There would be a bit of guilt laid on everybody. We would own our own responsibility for having made only 4 desserts rather than 6. And the next time that we make anything chocolate, we would make a double serving for ourselves. But there isn't enough here to pin it on any particular person.
So insufficient evidence and a failure of the exercise to provide information about another possible perpetrator.
Yep.
Very good. Thank you. Are there any other groups that are ready to go? Yes, over here. Yes, just on the other side of the camera. Would you hold your hand up again, please, sir? Thank you. We'll get you the microphone, and when you get it, your first name and where you serve, sir.
Lee Wilson, Coos County, Lincoln County, and the Dalles. That's Wasco County.
Diversity.
Yeah.
Yes. Thank you. So, who took it?
Well,
what did you do? And how
Portland,
did you
our
come to the
decision was not to even deal with it.
Mm-hmm.
No, I'm just teasing. We had to make a decision. We didn't even want to read it.
I'm sure persuasive
Just wanna
about the
go lunch
rules.
Actually, as a parent, there's a learning process for the children. I believe that we all decided that Jane did it. She set up brother. However, they shared and when he caught her eating the chocolate, she teased him and said, "Brother, you got to try this. This is so good." And he says, "Okay, but you back me up, I back you up." And they shared the same spoon. Why they didn't put the bowl back into the refrigerator, I would have as a child. I would have put it back in there empty and said, "I don't know how that got empty," and shared in that responsibility. But as a parent, we thought, well, we'd separate them and talk to them individually and bring them back together and talk to them, because the bottom line is the lie. And that's where you have to, as a parent, make some decisions as how you're going to teach them to process that lie and be honest and truthful and have the integrity, which is a big word for little kids, but you can teach that. So it's a teaching moment for the parent.
Mm-hmm. Wow. So have a very very teachable moment being used there, and not just solving who did it, but we have solving every detail of how it was done, and then a little bit of the primary perpetrator and the Johnny-come-lately to the offense. All right, thank you very much. Was it difficult to get consensus? Were there any holdouts for Tom as the perpetrator?
I just made it all up. No, I think we just talked about it, and I just kind of gathered everything and put it in my words, which doesn't make a lot of sense, but that's.
Thank you. Were there any tables who saw Tom as a perpetrator? Raise your hand. Okay, let's hear from you then. And just for everybody's benefit, your name and your position.
Christina Jagernoth, I'm CRB staff. My deciding, the things that caused me to decide that was that Tom didn't eat his dinner. There was that dirty towel that looked like there was chocolate on it in his room, and there was that very clean spoon in the bathroom cabinet, and Tom tends to be clean, so I would suspect that Jane wouldn't have cleaned that. And as punishment, I wouldn't have punished either one because it's just chocolate. Who cares?
So a firm determination, but mercy on on the punishment. Yes, firm but merciful. But your table was unable to come to a consensus.
Yeah, I think I'm like the George Bush decisive. I can't believe I'm saying that. And I think that they were the more deliberative.
What about either of these tables to my right? Were either of you able to come to a consensus? Oh, I'm sorry, let me get you the microphone, sir. Or I'm sorry, wait for Megan to get you the microphone. I'm not doing anything.
Fred, we're from Lane County.
Thank you, sir.
Well, we agree with that table. We thought there was really insufficient evidence. But one thing I don't think we've heard, well, first of all, we thought maybe it was planned. We thought maybe the father was involved in this, that he liked chocolate. But one thing is, the evidence looks like Tom, but you have nothing on say that the mother didn't ask Tom how that paper towel got in there. What is there chocolate on there? I mean, you could hear, as you say, his day in court and why they both denied it, but why is this paper towel here? What is this on there as such? And so if we still couldn't get which child did it, we thought as far as the punishment that my wife came up with the idea was a very good one. Since the mothers spent so much time preparing this from scratch, so the children knew how much it took, that they would have to go and make it also to show them how much work was involved, and maybe the guilty party then would say, hey, I did make a mistake on that. And as far as the punishment is concerned, that would be part of the punishment, or also since they like chocolate, no chocolate for a couple of weeks or something. But I don't think I don't think there's a consensus we would come really down hard on them as such. As you say, it should be a learning experience for them. And if you punish them really hard, then there might be they might do something more dramatic in the future.
The punishment, or the punishment must fit the crime, right?
Right.
And so in this case, it is going to exactly fit the crime in terms of you eat it, you got to know what it's like to make it.
Right.
This
and then we
wasn't
check out
easy.
the husband, of course, too.
All right, and then I hear in your processing of it and deciding that it was Tom.
No, we didn't. We said we'd have to hear what he had to say.
Oh,
We
okay.
thought with that table there was not insufficient evidence.
Okay, that's right. That's right. I do feel a little bit of a lean though, but not firm enough to make the call. You were articulating some of the evidence about the fact of the towel being in his normally clean room.
Right.
And just when you said that immediately, I was thinking the old prosecutor in me said, there's no coincidence is evidence. And so,
But he might have a ready answer on what that really, if they check, this is not chocolate, this is something else that I've had. So
every
you have
word
to-
is
right,
important.
right, right.
Yes, it was not definitively chocolate.
Right.
Very good. So just a quick show of hands. How many of you individually in the final determination felt like you could not decide? You could not decide who did it. Raise a hand. Okay. It seems like about half or more of the room. Was there anyone who said that any of you who, if you couldn't decide who did it, you would punish them both? Raise your hand. Again, a very popular answer. Does anyone else feel that their reasons for punishing both haven't yet been said? Anything more to add on that? Okay. In the corner, everything about punishing them both. I know I heard you talking about your rationale on that. Anything unsaid so far? Oh, a hand over by the camera.
I think this was a parenting failure. Why would you separate the kids from the family for dinner? How are the kids going to learn social graces if they're not allowed to participate?
All right, I'm going to run from accountability. I didn't write the problem, but no, that was weak. So
one more thing, I think Dad did it.
all right, I did this with a room full of judges. Anybody, just for giggles, want to know how it came out in there? So there were 4 rows, and every row made a decision. They all agreed that it was a tough decision. My row, the back row, we felt that it was Tom, and a lot of the same reasons. And one of the other things that came up was the fact of never having lied before, and most of the other rows, all of the other rows, thought that it was. I'm sorry, no, never mind. We thought that it was Jane, because Tom had never lied before. The other rows thought that it was Tom, but there were a lot of people individually who said, yeah, I think that it's them, but I don't. None of the rows thought as a group that there was enough evidence to say, Tom, you did it, or Jane, you did it, and we're going to be punishing you. And so all of my colleagues said, we'll punish them both. But again, we heard a lot of the same things in terms of how you would address it with them. Someone was talking about it really coming down to the issue of honesty, telling the truth, and that being important. No one came up with the idea of a punishment of making them prepare the chocolate mousse. So I think you guys come out ahead on that. So thank you very much for your participation on that. So this is an exercise in group decision making, which is what you as CRB members do regularly with the group. And so what I want to go through is there's been a lot of research over the last couple of hundred years, actually, and we'll look at some of the old thinking and some of the more recent thinking on group decision-making, and the advantages and the disadvantages, or the traps, if you will, and then finally, what can you do to avoid stepping into one of those traps? So in our history as a country, the importance of group decision-making can be seen on all sorts of levels. We leave some of the most important issues of individual justice to juries. We have Congress, the Senate, often called the greatest deliberative body in the world. Okay, Snickers, but let's think of the potential design and not the reality that we find ourselves in. Hasn't always been this way. And then there are decision-making boards at a number of levels, including the CRB. So right now there is a very high regard for group decision-making, as you can see from that. If you would like to get a good historical account of how group decision-making was regarded, I recommend the book The Wisdom of Crowds. It talks about potentials and pitfalls. In that book, there's historical discussion. A researcher, Gustave Le Bon, back in 1895, in his book, he studied crowds, and you can just see by the use of their words, crowds, rather than groups. The word choice tells you a little bit about where they are. Mr. Le Bon wrote that crowds can never accomplish acts demanding a high degree of intelligence, that they are always intellectually inferior to the isolated individual. He had a lot of company back then. Another researcher named Charles Mackay, in his book, said, "Men, it has well been said, think in herds, and it will be seen that they go mad in herds while they only recover their senses slowly and one by one." It's not just folks that we haven't heard about. Henry David Thoreau said, "The mass never comes up to the standard of its best member, but on the contrary, degrades itself to the lowest common denominator." There is a professor, Francis Galton, who also had disdain for groups and thought that important decisions really needed to be made by a particular select few. In the journal Nature, though, he did have an open mind, and he wrote about an experience that he had at the West England Fat Stock and Poultry Exhibition. So it's kind of like one of your county fairs where they've got a big ox and the people attending are asked to guess the weight. So he, on the spot, decided that that would be a good way to study and show how crowds just don't know anything. So he examined all 800 tickets that were submitted and expected the guesses to be wildly off the mark. The tickets showed that the crowd guessed the ox would weigh 1,197 pounds. The actual weight, 1,198. So Professor Galton grudgingly wrote, "The result seems more credible to the trustworthiness of a democratic judgment than might have been expected." But today we know that there are a number of advantages to group decisions, and that's why more and more we formulate our important structures towards group decisions. Another recent book, The Secret of Happy Families, the writer develops strategies for using decision-making in your family group, from secrets culled from CEOs, from special forces leaders, have to make important and tough group decisions, family counselors, and others. In that book, and this is reflected by other research, the advantages of group decisions include the possibility that everybody can bring their collective knowledge and experience to the table. So you have multiple people from all sorts of background with all sorts of skills, and it is more likely, if you tap into your collective knowledge, that no stone is going to be left unturned, that you won't miss something by being hasty. And when you then have to carry out action in say, like a special forces or a project management type situation, by making it a group decision-making process, everyone has a vested stake in the performance of those decisions or directives. Bottom line, group decision-making, you do it right, and it invariably leads to better results. There are, however, dangers in group decision-making. What we see here with the motorcyclists could be an example of what is known as risky shift. In other words, it is not just science, but it is something that you probably know at your gut level, that folks in groups are more likely to take risks than they are individually, because they will have the support of other people. It is one way, we see it with teenagers, where things start snowballing out of control. Oops. It is, and it isn't, because it comes down, there's a group that makes a recommendation, right, but then there is a president and a Congress, so I guess the Congress that has the authority to declare war does that. But there's a dispute right now about, are we really following the process? Right.
No one else agreed with him.
Yeah. Groups can go wrong. Groups can go wrong, as we're getting into here, and so there are a number of ways that can happen. I don't want to step. I've hinted at the politics. I don't want to step too further into that. But there is a phenomenon called groupthink, and it's been studied for probably about 30 years. And what they have found is that groups are often controlled, and this you've got in your example, you got some very strong personalities in those groups. Groupthink, one of the things they found is the person who speaks first and loudest. So in other words, your alpha personality, your type A personality, probably going to be most likely to come right out with what they say. There is a tendency for the group to follow them. That is, to make decisions based on the power of the personality rather than the power of the facts or the power of the rules. So not going through an evaluative process, but giving in to the personality. So studies have shown that people tend to follow that loud, opinionated, strong first speaker, even when they are known to be wrong. Guys, I'm sorry about this, but another recent study in the University of San Diego found that men are more likely to engage in or endorse risky behavior, because we as a gender tend to discount the probability and severity of negative outcomes. So another thing, if your alpha personality happens to be a man, that could be in play. And this is also something that they see that is common in groups that have worked together for long periods of time, because they may be afraid of speaking up and challenging the opinion held by some of their members, or you get a little complacent, or you may think, well, this is how we've done it before. So it worked with this. We did it this way before, we'll do it this way again, and forgetting that every case is unique, and there may be some unique circumstances that you are missing in that. So I've got here, in going through some of the dangers of group decision-making, I've got a number of tips recommended from experts, and then I've got some own recommendations of my own that I brought for you. So strategies. First of all, diversify your group. If part of the strength of group decision-making is the collective experience and knowledge of its members, if you're all carbon copies of each other, you don't really have as strong a group as you do, as if everybody is bringing different things to the table. So experts recommend diversifying your group by background, age, gender, ethnicity, those sorts of things. For field managers, as you are putting your groups together, I would also recommend just your sense of introverted and extroverted personalities, because again, those are important as well. They each have something to bring to the table. Your extroverts, you're not going to have to pull out what they think from them. They're great leaders naturally, but you need also a balance, and you need to be able to pull out the information from the introverts and make sure that your extroverts don't dominate the conversation. So diversify. Experts also recommend voting about a matter before discussing it. I don't know that this would necessarily be helpful in group decision making, but they found that for juries and for board decisions, that sometimes this happens so that people are thinking about it and evaluating and taking a position before they are dominated by a stronger personality. That's why some juries use secret ballots, or at least writing down their positions so they can collect their thoughts and know what they think individually. But as I described it, there was a recent study that just came out. You may have heard about it, discussed in the news this week. It had more of a business management context, but it was looking at introverts and extroverts and their value to a business organization. And you would normally think, and it is true, that the extrovert has a lot of advantages in getting hired and in promoting, because they're going to sell themselves better by nature of their personality in the interview, and they're also going to promote their own accomplishments, rightly or wrongly. That's part of their personality. But it looked at the value that introverts have to the organization, and the bottom line was that you need both. For a strong, healthy, and most effective organization, you need both, because they both have strengths that you need. So again, in terms of trying to manage a deliberative body, one of the things that you could do is start your conversation and start with some of the quieter people first, because we know the dominant ones, they're going to speak, but we can hear from them last. And this is a way that I would suggest we are less likely to have people silence themselves because they're afraid of maybe offending or challenging one of their colleagues. Again, we want to leave in due process. We want to make sure that we have considered everything important, and that is where all of the individuals in your collective background and experience come in. Most of all, though, just being aware of groupthink, risky shift, and some of these dangers. That's what's going to help you, because I told you I'd bring him back. A man's got to know his limitations. A person's got to know their limitations. So one classic example that we see of group decision-making comes from the film 12 Angry Men. Anyone seen the film or the play? Again, I will apologize about the title. When it's done now in high schools as a play, it's usually retitled The Jury, with apologies to Alfred French publish it. But could anyone give us the basic plot of 12 Angry Men? Anyone remember? Okay, we've got a jury on a murder case. And it starts off, it takes place entirely within one room, a jury deliberation room. And like the title, in the movie, it is a jury of all men. And so it begins at the very beginning of their deliberations, they take an early vote, and it is 11-1 to convict for murder. And it seems to be a pretty open and shut case. But the one not guilty is played by Henry Fonda. And his character had questions, and he wanted to go through the evidence. And there were some who were more willing to do that on the jury than others. And there were some who felt that it was open and shut, and they wanted to move on. There was one gentleman who actually had tickets for a baseball game that he was dying to get to. And I think if we go through, it was a great movie. It's a good play if you ever get a chance. Some of the traps are clearly set up there in 12 Angry Men. There were strong personalities trying to push the group in their direction. The fact that it looked like there were so many who thought that it was guilty lent weight and strength to that decision rather than the evidence. So this feeling that, well, everyone thinks he's guilty would lead people to jump on that bandwagon more than the weight of the evidence itself, and gave them pressure to conform. There was also a natural belief in the moral correctness of what they were doing. There was no doubt that there was a murder. It was a whodunit. But having, in their eyes, evidence of who did it, they wanted to deliver justice, punishing a bad person. There's also some confirmation bias. There are references to the accused as a slum kid. He was an ethnic minority. There are references to that. And so those were the things that were standing in Henry Fonda's way. Here we see a scene where they're examining the use of the murder weapon. I think that we have time, so I'll tell you just a little bit about what you're looking at right there. So the murder weapon was a switchblade knife. The trajectory of the stab wound was from up to down. And Henry Fonda was talking about, well, how would it have happened? The gentleman you see there to his right was the loudest and strongest personality, and a very, very interesting character in the play. And he says, well, I'll show you. And they get together, and he raises it up, and everyone fears because it's getting kind of hot between those two. And then all of a sudden, having seen that, one of the other jurors says, wait a second. We carried these all the time in my neighborhood, and you would never stab that way. You say, why not? And he says, well, the value of the switchblade knife is concealment and speed. So when you're going to use it, you bring it out and you open it, and he clicks it. He says, and then you use it. So he's got it in an underhand. He said, if you're going to use it, you would never use it that way because you would have to switch it from underhand to overhand. Pow. And that's when they would get you. You would never use it that way. And it was one of several turning point moments. But what are some of the strategies that Henry Fonda's character used to help work through the process? He remained open-minded. He encouraged discussion, and he was excited by the invitation of doubt rather than being afraid of it. It wasn't personal to him, and he made sure that in going through the positions that other people had, that he respected their opinion so that they could change their opinion by saving face. So, in other words, if you feel like something isn't being considered, it is instructive of how to bring this up without challenging or necessarily hurting one of your colleagues. One of the characters played by Jack Warden on that front said after that turning point that, this guy, he's got the soft sell. So again, it allowed discussion, and it allowed people to change their opinions and yet save face. And as everyone began to agree with Henry Fonda's character, this illusion of unanimity was punctured and no longer became a convincing force in and of itself, when really it's not relevant to the decision. So I know that we have a little bit of time left, but I want to just, in sum, say where this is going. If you employ sound decision-making principles, the group decisions allow for the collective experience of all of your members, their collective wisdom, and can and should lead you to a better decision. Again, here's an author unknown. Team means together, everyone achieves more. Any questions? Yes, sir.
I had one.
going back to the dangers of a group decision, when you're talking about the studies that are done, when the alpha takes charge and the one that speaks first and loudest, usually the group goes along with that.
Well, not usually, but I don't want to get into usually or
okay,
frequency.
well, my question was, I was wondering when they did this study if they did an age factor in that, because I remember when I was young, I probably would have gone along with that. But as we get older,
Right.
you know, we're more questioning. Even though I think, you know, the consensus for it, I would disagree more than before. My wife says I'm sometimes too opinionated on some things. And, you know, even though everybody else is going along with it, you say no. So I just wonder if there's an age factor. As we get more experience, we're more likely to speak out when we think, even though the group is saying something, we think they might be wrong.
That's a great question, and I'm sure that there probably are studies on that. I am not aware of any of them, but again, it would seem natural that that a person's background, whether it be age, experience, or position, is going to lend some convincing force sometimes. So, in other words, a very strong and opinionated person who gives you nothing else to agree with them, you know, doesn't bring a lot to the table. Otherwise, they may not dominate that group so quickly and early in the process. Whereas there might be a little bit more deference given to someone a little, you know, more senior to them, for example, or more senior in an organization. But as a bottom line, I don't know the answer to that. It's a great question. Any other questions? Yes, sir.
One of the processes in CRB, at least in our board, is that we make decisions as a board with several people on the board and with the parties involved in front of us. Now, do you have any comments about that particular situation, any hazards or benefits or liabilities to making a deliberative decision in front of the parties involved?
Right. Well, I have to do that as a judge. Right? I don't necessarily have to. I could take matters under advisement and issue an opinion letter that they get somewhere else. I always try to rule from the bench if I can. There's differences, obviously, in what I do and what you do, but I think I have an answer that may help somewhat, and it's this. I think that as a judge, I not only have to make a decision, but I have to explain it in a way that's going to withstand scrutiny. And I mentioned earlier that people want to win, but they expect to be heard. And so I try to deliver my finding in a way that is as positive to the party that does not prevail as possible. In other words, I relate back to them the things that I heard from them that I agree with, that in the end don't end up being as influential to my decision. But in other words, if you pare it back to them what their position is, but then tell them what was the persuasive evidence, I find more often than not that I get parties nodding along with me even while I'm finding against them, and at the end they express thanks because they feel heard. So they want to win, but they expect to feel heard. And I don't know if that's something that could work in a CRB process or not. It may be a little bit more binary in terms of how you answer the question, but if there's room to explain it in any way like that, that would be my observation.
I think that would work. The one little nuance, though, is there's not just one judge, there's three. And so you're kind of deliberating among yourselves as well as maybe saying you're hearing what the parties have to say.
And deliberating in public?
In public.
Oh, yes.
Yeah,
well,
see, that's a tough...
That's tough sausage making. Well, with that, you know, I would probably come to. There's a lot of ways to do this, and one way may work great for one group, may not necessarily work for another group. But just going through some of the things I suggested, there's going to be some where I think, especially if you're an experienced group, it's obvious, and you don't really have to talk. You could tell by looking at each other where you are, and so it would probably be okay just to proceed. But for ones where you think it's going to be tougher, you know it's going to require some talk. Well, then I would probably have a process of going around with each board member and trying to make sure to draw out some of the quieter ones and what they think, and you know, kind of ramping up to some of your more vocal board members, and then give another go around and see where things are. And it is difficult, as we saw here, to get a large group of people to agree on things sometimes. And but to the degree that you could echo back to them the party that doesn't prevail, something to say that you heard them, so they know that they were heard, even if they didn't prevail. That if you could factor that in somehow, that would be my strongest recommendation. I think we are out of time. Is that all right? So thank you very much, and make good decisions. Thanks. Thank you.
That